Welcome to Broadband Breakfast Live Online. My name is Drew Clark. I'm the editor and publisher of Broadband Breakfast, and today is March 23rd, 2022. And I'm so happy to welcome you and our guests to this Broadband Breakfast Live Online event. We're going to be talking today about big tech and the American Innovation and Choice Online Act. I'm sure we'll talk about some other legislative proposals that are out there and that are part of, I guess, effectively a ratcheting campaign in Congress, bipartisan it seems, right? Although there's certainly fissures in that alliance against the biggest of the big tech companies. And like I said, we'll drill into this just now. Before we get to that, though, I want to just make sure everyone has a little context and information. We at Broadband Breakfast, we're a online news and events community. Our focus is higher capacity broadband. We call this Better Broadband, Better Lives. And so we care about the infrastructure, but we care about the applications and use and the policy issues raised by big social media platforms and their role in the economy. We cover these issues, these stories on Broadband Breakfast, and have focused on Section 230 as well as privacy issues and antitrust issues. And this is something we do like to do something on, I guess, every month. We do have an event, a Broadband Breakfast Live Online event every Wednesday at 12 noon Eastern Time. Next week, we're going to be talking about big tech and its impact on the environment, or technology, maybe not big tech, but technology and its impact on the environment. We're going to be talking about broadband mapping in 2 weeks' time on April 6th. And then on April 13th, I'm really excited to share with all of you the news that Alan Davidson, the administrator of the National Telecommunications and Information Administration, the Commerce Department agency, and the agency that is the primary entity responsible for the $65 billion in infrastructure funding for broadband. He will be in person at Broadband Breakfast for lunch. That will take place both online and in person, so you can still watch it as usual, and all of the way and the channels that you watch regularly. But you will also have the chance to visit with Alan in person if you register and sign up for our Broadband Breakfast for lunch. So this is all available on broadbandbreakfast.com, and encourage you to visit there so you can see that and enjoy that. I also want to give a shout out and a thanks to the sponsors of Broadband Breakfast that make our programming possible. They include Utopia Fiber, Lit Communities, Broadband.money, Broadband Now, Powerhouse Management, Lightbox, Samsung, Render Networks, Positron Access, and the California Emerging Technology Fund. Thank you to each of our sponsors for your support. So without any further ado, I'm going to go ahead and open the floor to each of our three panelists that we have here today. I'm going to introduce them and then give each of them a chance to have their own remarks about the topic of the day, of course, big tech and the American Innovation Choice Online Act. Leading off our discussion will be Antoine Prince Albert III. Prince is the Government Affairs Policy Counsel at Public Knowledge, and he's been focusing on this issue at Public Knowledge for the past year, and really excited to get the perspective of public knowledge, which has been on the forefront of tech policy issues for more than 20 years. And in some ways, I view it as an interesting evolution of public knowledge. So I don't know if you have some thoughts on that, Prince, but I wouldn't have expected to see as much criticism of tech coming from public knowledge, but we have. We're going to then hear from Arthur Sidney, and Arthur is the Vice President of Public Policy at the Computer and Communications Industry Association. Arthur has been with us before. We're grateful for his repeat appearance here. He's been at other Broadband Breakfast Live Online events, and Arthur also was the chief counsel to Representative Hank Johnson, the chairman of the Courts, Intellectual Property, and the Internet subcommittee in the House, as well as being a international trade attorney with the Commerce Department. So he's very well equipped and focused on this. And CCIA, of course, in some ways, this is kind of the bread and butter issue for CCIA. So, definitely want to hear Arthur's thoughts on these topics. So welcome. And batting cleanup will be Patrick Hedger. Patrick is the executive director of the Taxpayers Protection Alliance, which is a nonpartisan taxpayer watchdog group. And he has worked previously at the Competitive Enterprise Institute. So we're looking forward to hearing about the kind of specific focus of the Taxpayers Protection Alliance and the project that it's involved with. So with that introduction, Prince, let's turn it over to you to tell us why we have a problem and what the American Innovation and Choice Online Act will do about that problem.
Sure. First, thank you, Drew, and thank you, Broadband Breakfast Live Online, for hosting me and having PK represented here. I'll comment quickly, Drew, about PK and why we're commenting on this or why we're in the space. So in general, public knowledge, we are an organization that promotes freedom of expression and open internet and access to affordable communications tools and creative works. And we shape public policy on behalf of the public interest. Our bread and butter, of course, started with telecommunications issues, but for over 12 years now, we've probably been doing kind of around the ecosystem of technology and telecommunications law and policy. And so a lot of work we've been doing at Public Knowledge that I've been doing with a team of folks in competition is really analyzing the market, what is going on in big tech, and why do some of the, outcomes that were advantageous to us 15 years ago, 10 years ago, 8 years ago, we're no longer seeing those benefits as radiantly as we once did. So I'll start by explaining the dynamics and some of the problems with digital platforms markets generally, and then I'll talk about what the non-discrimination bill, as I call it, will do. So first, I want to talk about the nature of data, right? I think that's like a really strange starting place, but important. The nature of data is so different from physical goods, right? Physical goods are made with other resources and usually require some kind of industrial expertise to fabricate them. But data, however, is non-physical, it's self-executing, easily duplicable, multi-locational, and instantaneously processable. So it's the natural resource of the digital market, and it's so easy to produce and so easy to get. And the streams of data are easy to control because he who owns the platform where the data is made and stored can own data flows and control access to the other data flows to, data flows from, and data flows with, right? That information in that platform. So that's the inherently unique raw material of the digital market, but there are specific economic factors that contribute to why digital markets are so unique. First, extremely high barriers to entry that make it hard for new entrants to break in, right? New tech companies, smaller tech companies to break in digital markets and stay there. According to 2022 reporting, the US has the largest tech market in the world, obviously worth $1.6 trillion or more, probably more at this point. However, the tech sector is the highest startup business failure rate industry, with 63% of tech startups failing, right? And fail for a lot of reasons. But I think that's an important component here, that this industry, it's really hard to break into and stay into for smaller businesses. Second, you have network effects that lock users in, right? There are no alternatives either. So when you're on Amazon, Facebook, Google, you can't communicate with other platforms. The only ways to communicate with your friends, the products, the services that you know and that you love is that you access them through that platform. And, we can talk about kind of some of the ways that legislation looks at network effects, but they are implicated more largely in the problem. And then next we have economies of scale and scope, where platforms can offer, the services to the next user for a marginal, no, or negative cost even, offering one more subscriber an Amazon Prime account or a Gmail address or an iCloud account or a backup IG page doesn't cost these platforms anything, right? And then you have the economies of scope, where platforms can offer more and more tabs, more services to already existing expansive networks without any resource limitations. And in our economy, companies large and small compete for consumers, right? That's what capitalism is. That's what it does and what it's supposed to do. And they compete for consumers and compete for consumption. But the high barriers to entry, the network effects, economies of scale and scope, and the inherently fungible, manipulable, and ubiquitous nature of data make these markets unique. These aforementioned factors give Apple, Amazon, Facebook, and Google an economic incumbency and supreme advantage over competitors, to the point that these markets are at the risk of tipping toward monopolization, an end state of economic stagnation and predatory conduct towards consumers. And in particular, I'll say, why the discrimination problem? The largest tech companies own and operate platforms that attract everyone to the platform. People wanting to communicate with each other, share information and experiences, art, media, goods, services that they love with the world. And these platforms have also attracted business users who want to be where the people are in the marketplace, especially small and medium-sized businesses, right? And large businesses also have become dependent on large platforms. These business users, small, medium, and large, they depend on access to the platform to meet consumers, because consumers have become so accustomed to finding their products and services on large platforms. They don't go to individual business web pages at all anymore, almost. And many small and medium-sized businesses have even gotten rid of the expense of managing extra web pages. So they exclusively operate on these platforms. And small businesses, exclusively almost use Amazon, Facebook Marketplace, Instagram Shops, et cetera. But these large platforms have a host of unique advantages. They control the interface. They lead consumers to certain products and away from others with the control of that interface. They can survey an entire category of goods and services offered by smaller businesses, replicate them, and undercut competitors' costs, driving the little guys out of business because they can't afford the profit haircut or even the profit deficit that the platform can. The platform is cross-subsidizing their entrance into markets with platforms from other adjacent business practices. A huge advantage against smaller businesses whose number one reason why they fail is revenue and capital. And so they can't afford to compete with platforms anymore. And third, we know that platforms sell ads for revenue, but platforms can sell small companies. They can tell small companies, hey, if you want to reach more consumers or get prioritized on, our network, why don't you purchase additional services from us, right? Kind of bundling and tying services and goods to kind of extort prioritization. And there are nuances to this problem, but what the non-discrimination bill, as I'm calling it, the American Innovation and Choice Online Act in the Senate, is doing is it prescribes a list of anti-competitive behaviors where a larger platform would discriminate against smaller platforms and would be economically incentivized to, right? It's not businesses want to hurt, platforms want to hurt small businesses on purpose. It's because the economic structure and incentives lead them toward wanting to capture an entire market. So there are, the non-discrimination bill will prohibit about 10 types of anti-competitive and discriminatory conduct, self-preferencing its own products or services over competing ones, a covered platform restricting competitors' products and services at all, the covered platform applying or enforcing terms of service to discriminate against competition, and inhibiting competitors from accessing or interoperating, conditioning prioritization on the purchase of other services, using competitors' non-public data to compete against them. And there are some others that I'm sure we'll discuss, but I just wanted to kind of open it up there.
Well, great. And thank you for doing so, for giving us that overview and obviously still dipping into the specifics that are there for the Innovation and Choice Online Act. Let's turn now to Arthur. Sidney, tell us a little bit about yourself, about CCIA, and about your thoughts and concerns, I'm certain, with this legislative bill and others too. So Arthur, take it away.
Okay, good afternoon, Drew, and thank you for having me again on Broadband Breakfast. Very happy to be here. I wanted to say that I'm Arthur Sidney, VP of Public Policy at the computer and communication industry. We are a 50-year-old tech association representing small, medium, and large tech companies in the ecosystem. We are 50 years old. If you can imagine what tech was like 50 years ago, we were there and in those fights. So very happy to be here on the panel to have this very important discussion today. I'd like to focus my conversation today on some context. So starting off with context, then a discussion of the House and Senate judiciary bills together, consequences for the consumers, and then focus upon national security implications and consequences. So I'll start off by saying that the extant rules on competition are working. The Sherman and Clayton Act have been the hallmark of antitrust laws for over 100 years and have applied to different markets, industries, and have fostered competition. The consumer welfare standard has been the prevailing standard, wherein the issue is competition in the interest of consumers by looking at price effects? Are consumers harmed by competition? What is needed is vigorous, evidence-based enforcement, not new laws. I would note that there was a recent study, a 22 study by NERA, which said that industrial concentration has been declining rather than increasing since 2007. And rising industrial concentration is often a sign of increasing market competition and associated with positive outcomes such as job growth, job creation, and higher compensation. I would also share that the increased output, job creation, and higher compensation in the tech sector is also increasing. There is decreased inflation in the tech sector compared to other parts of the economy. Prices for online goods and services are lower today than they were in 2014. The US tech industry is the most vibrant and successful in the world. Companies affected by the House Judiciary and Senate Judiciary antitrust bills have allowed us to work, worship, play, and continue to conduct business and resume our lives during the pandemic. They represent iconic brands that are beloved by Americans and individuals the world over. S2992, the American Innovation and Choice Online Act, and the series of House Judiciary bills, wherein there are 6, would impose an economic cost of $319 billion if they were passed. And of those high prices will be passed on to consumers, making services less convenient, less integrated, and more expensive. The bills will not stabilize prices or reduce inflation. Online goods and services have been the cheapest, as I've mentioned, since 2014. And it's important to note that because of the prescriptive definitions of covered platforms, at least 13 additional US companies will be covered by the bills and over 100 companies by the 2030s. In the near term, other companies that will be included would be Berkshire Hathaway, Visa, JP Morgan, Chase, Walmart, MasterCard, PayPal, Home Depot, and a host of others. These bills will hurt American companies more than foreign-based companies. Venture capital investment in startup firms will be reduced by 12%. And it is against this backdrop that the House Judiciary Committee conducted their 16-month investigation into the tech industry from 2019 to 2020. They produced a 450-page report, and on June 11th, 2021, the House Judiciary Committee marked up 6 bills. The markup occurred on June 23rd and June 24th, and it's important to note for all of these bills, there were never any hearings on the 6 House Judiciary bills or the Senate bills, namely 2992, the American Innovation and Choice Online Act, and S2710, the Open Apps Market Act. So process wasn't even adhered to. And because these bills are so important, they are changing from the consumer welfare standard, they're changing antitrust, the bill should have at least been ventilated and heard on and had legislative hearings for each of these bills. And those were raised at the markup on both the House and the Senate, by both Democrats and Republicans. And so S2992 was introduced in October 2021, and it was marked up in January 2022. And as was said, the bill is a non-discrimination, non-self-preferencing bill. Now, the important thing to note here is the bill actually penalizes big companies. It has a focus and only applies to what are called covered platforms. And covered platforms are defined as companies with 550 billion in market capitalization and 50 US-based active US users, or a company with 550 billion and 100,000 US-based business users, which there is no definition of business users except for those that use or that are likely to use the internet. So query who even that applies to is a concern. And then with the manager's amendment for S2992, the bill was extended to include companies with 100 billion worldwide users. And so the bill, as was mentioned, only focuses upon Google, Facebook, Apple, and Amazon, perhaps Microsoft, and with the manager's amendment may include one foreign company. And so that's important. That's important to note. It is a non-self-preferencing bill. And the other important thing to note is that violation of any of the indicia that Prince mentioned is 15% of revenue for any of these companies. And so the bill has defenses, but the defenses are so narrowly drawn that they would be unavailing because the defendant must show by a preponderance of the evidence that the conduct has not resulted in and would not result in material harm to competition, which is yet another problem with the bill. The bill was so hastily drawn that there are new concepts that are introduced in antitrust law that we've never seen before and that are nowhere defined in the bill. Instead, the bill leaves it to regulatory authority to define what is material harm to competition. And so there are a myriad of problems. I think one of the most important problems with the bill is that it picks winners and losers. It picks 5 US companies, kneecapping the most successful companies in the world, and not applying or not having corollary regulations to foreign companies. And so therefore, foreign companies are allowed to interoperate and do the things that are prohibited and preference and do the things that are prohibited for US companies. And it's important to mention the national security implications because this bill comes on the heels of the Senate passing the USICA Act, United States Innovation and Competition Act, which was an act that was supposed to, or an act that will help US competitiveness vis-a-vis China. China is a real threat. I'll talk about that more in a moment. And it devoted billions of dollars, $190 billion in R&D to compete against China in R&D, or to $190 billion in R&D to compete against China in AI, quantum, cloud services, and other important things. And yet this bill, 2992, and its brothers and sisters on the House Judiciary side are kneecapping US companies. And so the bills actually would curb innovation and would be problematic. Again, they don't apply to any Chinese companies, or there's only perhaps one Chinese company that's in scope, but our foreign Chinese and Russian rivals are left out of scope to compete against our companies. And moreover, some of the provisions, including the forced interoperability mandates, would actually allow foreign rivals to interoperate on these US platforms to the detriment of national security and others.
Well, thank you so much, Arthur, for those words and that framing. I think the controversy is joined, right? We've got a clear difference of opinion here. We want to make sure to get the perspective here from Patrick too. So, Patrick, let's go ahead and give you 5 or so minutes to talk about it, and then I've started to get questions, and of course, we encourage our audience, either on this platform or other platforms, to pose your questions. So let's turn it over to you, Patrick, to tell us a little bit about the Taxpayer Protection Alliance.
Yeah, sure thing. Thank you very much for having me, first off, and thank you for everybody attending and watching, and thank you to my fellow panelists for joining and offering their perspective. I'm going to try not to echo Arthur too much, and I do appreciate Prince being here from Public Knowledge. I agree with a lot of things Public Knowledge has to say on a lot of issues. Don't see quite eye to eye on this one, but I appreciate Prince being here and offering a pretty level-headed perspective case for the bill. So I'll just get into why we care about this bill as Taxpayers Protection Alliance. We are a nonprofit, nonpartisan taxpayer and consumer watchdog group, which is why the American Innovation and Choice Online Act, along with a lot of the other antitrust bills, which do similar things or do a portion of what this bill does, caught our attention. There are a few things with this bill and the broader package of antitrust legislation that we've seen on the Hill that concern us. And they can broadly be categorized into what they would do to the tech sector specifically, and then what these bills, and particularly this bill, the AICOA, would do to the role of government as a whole. So in terms of impact on the tech sector, again, to echo a lot of what Arthur had to say, the bill presents a lot of concerns on how it will impact consumers. There are some obvious ones, such as the ambiguous bans on self-preferencing. And now if you ask the layperson, what is there a problem with preferring your own products and services? I think the average person would say, hey, that just sounds like good business. To the consumer, this usually results in more choices, lower prices, and more seamless access to goods and services. You think of things like Amazon Prime, and you think of things, again, like Amazon Basics, where instead of just having the choice of the name brand product, you have the generic product, and you might be able to get one of those products faster and at a lower price. And no one really complains about self-preferencing, producers of other goods and services offered in markets included, when it's occurring inside of a physical space like a Costco. Nobody's complaining about Kirkland brands. Nobody's complaining about great value brands at Walmart. And nobody's complaining about at CVS when you swipe your little CVS card and they're collecting all sorts of consumer data in order to produce generic products that they put right next to the name brand products at a lower price. But those are things that would be banned from covered platforms. They would be banned from doing if they had a large enough market share. Just going to point out that some of the sponsors of these bills are, representing states that represent major retailers. David Cicilline, CVS, Rhode Island. You've got Target, Amy Klobuchar in Minnesota, and then you've got Tom Cotton that's signed on to some of these bills representing Arkansas and Walmart. None of those platforms, those physical platforms, would actually be covered by this legislation or other bills similar to it. These aren't really novel competition issues, in my opinion, and in the opinion of my organization. Sure, they may have access to greater consumer data, but at the same time, you see retail businesses doing as much as they can to collect consumer data and do a lot of the things that this bill and those like it would ban. So that's some of the obvious problems that we have with it from a pro-consumer perspective. My organization has taken particular interest in the less obvious problems for consumers related to cybersecurity. This bill goes directly after closed ecosystems such as iOS, right, the Apple system that's on your iPhone or on your iPad, in favor of sideloading and interoperability. And this is presenting inherent cybersecurity concerns and trade-offs related to malware, to which we've seen a lot of proponents of this bill kind of shrug. They say, well, personal computers are open ecosystems and those are just fine. And I would argue that's not really the case. Everyone knows it's easier to get malware on your personal computer, even an open system like your operating system on a Mac device, on a Mac laptop, by downloading files from the open web versus you look at Android, right, which does present that trade-off, right? You have interoperability and sideloading on Android operating systems versus not having that on iOS. And that works great for some people. You do get more choices in terms of applications and software that you can run on your phone. But the trade-off is that Android systems are anywhere at the very minimum 15 times more likely to encounter and download malware than an iOS device. And so while this bill is being offered as in terms of increasing consumer choice, The trade-off is that at the hardware and the operating system level, you're actually reducing consumer choice. And so I don't know if that's a trade-off that a lot of people want to make. The really great thing about an iPhone is that you can basically give it to your parent or your grandparent, and it's going to work most of the time, and they're not, it's kind of foolproof, versus a device where you could accidentally download malware. But there are other problems for even open ecosystems that this bill presents. The self-preferencing deterrence in the bill is so broad and severe, in our opinion, that imposing enormous fines, as I think 15% of revenue, as Arthur said, which is enormous, that other security features such as in-house security software creates risks for iOS, Android, and every other hardware and software provider that's out there. You create a natural hesitation or deterrence in companies to do beyond the bare minimum in terms of security, because you're shifting, and this is something I'll discuss in a second, you shift the burden of proof, really, and the burden of guilt onto the companies, that you're basically guilty until proven innocent of anti-competitive conduct. And that creates a huge deterrence in providing what is more than the bare minimum of consumer safety features. So this brings me to the second kind of broad category of problems with the bill and those like it, and this antitrust package, and that's the role of government. The bill is not just a narrow attack on the tech sector, but really the first crack against the foundation of antitrust law as we know it today, which is grounded in the consumer welfare standard. And so here are there's basically two big, significant and kind of troubling departures from the rule of law as we know it today. First is that it goes after companies and not necessarily just conduct. And so because you have market cap and user thresholds, other huge businesses will be free to do those things that those covered by the bill will not be able to do. You're still going to have Walmarts of the world building huge online presences and doing everything that Amazon does now, but Amazon will no longer be able to do those things. And that doesn't seem fair. That seems like explicitly picking winners and losers. And let's also not kid ourselves. We discussed a little bit before this conversation began about how this ties in with the debate over Section 230. Some, if not most, Republicans supporting this package of legislation are doing so purely for political reasons, to punish companies for decisions that they've made that are well within their First Amendment rights. If they can't go after them on Section 230 grounds because of the First Amendment, you're seeing Republicans just wanting to kind of take a bite out of tech companies as some sort of tit for tat for the perceived allegations of censorship of conservative views. And that's really problematic. That's not, we shouldn't be executing antitrust law based on political disagreements. Then there's the broader shift, as I alluded to earlier, of the burden of proof. Conduct that may be pro-consumer will be considered anti-competitive until proven otherwise. And this is going to have a chilling effect on innovation. And it sets a terrible precedent for regulation across all sectors to come. If we don't have permissionless innovation, if you don't have companies willing to just offer a product or service without thinking that it's immediately going to, cost them 15% of their revenue, think of the things that you don't have without permissionless innovation. You don't have the Ubers of the world. You don't have the Airbnbs of the world. If you have companies having to go to regulators and ask for permission to launch their product or service, you're going to have the entrenched interests come forward and say, well, that's anti-competitive conduct, that needs to be banned. And you can imagine the taxi unions doing that with Uber. You can imagine the hotel industry doing that with Airbnb. And I don't want to see that happening through the antitrust process. So overall, we see this as the first step along a path to massively ramping up economic regulation well beyond Silicon Valley, and using the weight of antitrust law by erecting huge ex-ante hurdles to the presumption of conduct being anti-competitive until proven otherwise.
Well, thank you as well, Patrick, for basically giving an additional perspective. Now, I want to actually pick up on a point you just raised there. About the role of targeting a particular company, right? And so, I mean, this is a question for both sides, right? The question for Prince is like, yeah, I mean, what do you think about that? Is it really fair to effectively target companies because of their size, right? Like their market cap of $550 billion, right? And the argument on the other side is like, Arthur had a great point about, by 2030, 100 companies will be on this list. Well, then that would presumably be a good thing because it'd be fair, more of those large companies would be covered. In some ways, it's a good thing, is it not, that our antitrust enforcement paradigm is not focused on big is bad. And so here there's a response or attempted response by legislators saying, well, if you can't do it through antitrust enforcement, we're going to pass a specific law going after those big companies and saying, if you're big and you do these things we really, put our policy disapproval on, you're going to be penalized. So Prince, let's let you take that first, but I also want to hear from Arthur and Patrick on that. How are we supposed to go after those companies that the public, through their legislators, their democracy, decides are simply too big?
Sure, Drew. And I just want to start by saying this is hard, right? These are products and services online that we have grown with, right, over a period of time. But the reality is what we're seeing through an economic analysis, right, is that just like in eras past where industries were overrun with one or two or a few very big companies, a company's purpose is to, generate money for its shareholders. There's nothing wrong with that. That's the American way. That's capitalism. But there gets to a point where market forces tip, and companies, when they become so large, aren't incentivized to do what consumers want anymore. So consumers are just going to take whatever they give because there are no alternatives. They've been eliminated from a marketplace, right? Or, price hiking because they can, push people to the limit of threshold of what they can afford and what they're willing to pay for, services and goods, and et cetera. So I just first want to respond by saying what the bills are doing, they are not targeting individual companies. If you control F these bills, you don't find Meta, Facebook, Google, Apple, Amazon appearing in your query. Okay, that's not the purpose. The bills are trying to encircle and analyze and scrutinize a market position. And the bills are flexible with thresholds to show that a market position would be indicative by a market cap, would be indicative, right, by some of these metrics of capitalization and size and usership in a delineated market or set of markets. And that would cover foreign companies if they do come in this market and become of a certain size, when that time would come or not. But the point is to, we want, and I'll go ahead and respond to the global competitiveness argument. I'll say, the idea is that for the United States of America to remain the leader of technology and continuing to introduce the world to some of the most important innovations in human history, when we compete, we win. And when we cheat, we lose. So let's compete, right? Like, let's have the best businesses, the best goods, the best services, have a fair shake on online platforms. And let's see who consumers vote for with their purses, pocketbooks, and wallets, right? Like the idea of platforms, acting in both lanes, controlling the interface and the portal on which we meet to, have these things, and then also controlling, operating on the goods and goods.
Yeah, let's come to that separation in a moment. But okay. I want to get Arthur and Patrick's response on, like, well, is this just an a priori impermissible thing? I mean, this is not a kind of a bill of attainder, is it? Because it's not targeting a company by name, it's giving a parameter, right? But Arthur and Patrick, what do you think to this point?
Yeah, if I could just interject, I'll say quickly, I think the bill very carefully picks winners and losers, and by circumscribing what companies are covered by the $550 billion market capitalization and the 50 million active US-based monthly users and 100 business users, carefully drawing that picture of who the companies are, it works to the detriment of America's competitiveness. I was going to share that, it's not this existential issue about America's competitiveness. It is no wonder that our companies are the most competitive and successful in the world because they provided a service. But the threat of foreign rivals, in particular China and others, is very real. President Xi announced in 2019, 2020, that by 2026, he was going to invest $1.4 trillion in the Chinese tech sector to overtake the United States. And this is all publicly available. And so, China right now has some of the most some 10 of the world's largest tech companies, several of the world's most downloaded apps, and the most patents in the tech sector. And there are rivals like Tencent, Alibaba, Baidu, ByteDance, and others that are real. And so, I think the bill does penalize big for being bad, but big qua big is not bad. It's just a matter of success. And so I'll stop there and
yeah. Well, I want to get into the separation argument. Patrick, do you want to say anything on this point about targeting a company by size of cap market?
Yeah. So first, two quick points. First is that I think the folly of doing so has been proven by Facebook's recent, or Meta's recent collapse in market cap. I mean, if they're at this market cap for the next 2 years, which is what some of the bills prescribe, they'll no longer be a covered platform. So I think that proves the market's a little more dynamic than the proponents of this legislation think. The second point is that I don't know if this is in the AICOA, but in a bill that was introduced by Senator Klobuchar and Senator Cotton, there's a date of enactment provision. So it means that only companies that are above the market cap at the date of enactment of the legislation will be covered in perpetuity, and not all the other ones that eventually grow to that level. So that really draws into question for me what the motivations are of Senator Klobuchar, who's the leading sponsor of all of this legislation.
Right.
So it does seem like a bit of a bill of attainder there.
Yeah, so thank you. We got some great questions. Thank you from Sean McLaughlin for asking these questions. I'm encouraging others to ask them too. And he basically has this approach. In our open internet advocacy, we used to talk about structural separation of the network providing connections and edge service providers. And then, that kind of raises all these issues of net neutrality, which we're not directly talking about today. But I want to get your thoughts on that. Prince, is this a fair lens for looking at it? Is there some structural separation argument to be made that, it's just impermissible for Google to enter maps and ratings recommendations because they're offering search? I want to hear it clearly articulated, because it's hard for me to kind of, pin it down. What exactly is the supposed unfairness for bundling or wrapping products together?
Right. So this, of course, you're speaking to the House proposal, because there is not, a Senate companion right now. But, this idea of the lens through which we're looking at this again is economic. And the House report did a really great job, that 450-page report that Arthur previously mentioned, right, was the culmination of a 16-month investigation, over 1.3 million documents, over 240 expert stakeholders interviewed, including the tech company CEOs and officers themselves. And that report scrutinized what is wrong with our markets that we're getting these weird outcomes, and how can we recalibrate them and fix them to make them competitive again. And there were a few policy solutions that echoed the same solutions or similar solutions that the European Union came up with, and that other jurisdictions throughout the world that are scrutinizing this same issue in their jurisdictions came up with. And those are interoperability mandates, non-discrimination requirements, prohibiting certain mergers, scrutinizing past mergers and acquisitions, and imposing line of business restrictions. And that is, the idea is that let's look at how companies got so large. There's reporting. I know the New York Times was one, the Washington Post in the last year or so, talked about the number of acquisitions that tech companies had made. And the idea that tech companies are acquiring at all itself is not a problem, right? Companies all often merge and combine and acquire things, but there's been reporting and some allegations and cases, that tech companies were acquiring, these tech companies in particular were acquiring companies to sit on IP and withhold it from competitors or kill competitors, in a way that turn of intent being anti-competitive, not affirmatively competing for consumer goods, but that offensive kind of knocking other people out of the playing pen with such large might and power and a bigger hammer is what we're trying to target. And there might need to be a retroactive review, right, of what has been done. And I mean, to do that, right, the bill by Representative Jayapal, like it imposes business restrictions that agencies would have to convince courts that they could levy. So it's not some automatic thing at the sign of enactment. All of these changes would be made and companies would be thrown into uncertainty. There would be some sort of investigation and building on information that we know thus far in a structured way that would lead us to the results that were sanctioned by courts.
Well, and thanks for highlighting that there are these other 5 bills, right, that the House Judiciary Committee passed in this 2-day major markup last June, right? And none of them have gone to the House floor, although I think it was referred that there's rumblings that Speaker Pelosi is going to attempt to bring 3 of them to the floor. And a great point earlier as well, that there hasn't been, quote, regular order on this. There hasn't been hearings. These are very substantial bills. Now, the one we're focusing on, the Senate bill, right, that has, of course, a House companion, doesn't deal with that tying or bundling, but it does have these other impacts that we've spoken on. And I want to kind of for the perspective of Arthur and Patrick, I mean, could you speak to, what is the economics of this? So Arthur sort of said it like there's not a problem existing. Sherman antitrust, the Clayton antitrust law is working. I've been covering this space long enough to recall the Microsoft antitrust trial 20 some years ago. And that matter, CCIA was on the, quote, other side, right? You were very much opposed to the Microsoft leveraging. What's different? I guess, let me put it this way to you, Arthur. What's different between what Microsoft did on these kinds of integration front or otherwise that you're not seeing when it comes to, Google, Facebook, Amazon, Apple?
Yeah, I mean, I'll say this. These goods and services that we're talking about, they are low cost or nominal cost. Consumers. There was a poll published by Morning Consult, conducted by Axios, basically saying consumers are not even supportive of these changes that these bills are trying to make. And then to your point of structural separation, for example, people enjoy the preloaded apps on their iPhone. They enjoy Amazon Prime next day same day service. They enjoy in the integration of Google Maps and search, and it's beneficial to them, and it costs them nothing almost. And I would also share that going in the way of ex ante regulations like we have in the EU is not advisable for the United States. We look back retrospectively. There are already remedies at law that we have from the FTC where they can look back and undo mergers. And so these bills, in particular the Ending Platform Monopolies Act that was referenced, create extreme remedies that the U.S. should be advised not to follow suit with.
Did you just say the FTC can go back and undo mergers, right? I mean, they could go back and undo their allowing Facebook's acquisition of WhatsApp and Instagram?
There's authority for the agencies to do lookbacks, yes.
Mm-hmm. I definitely want to get Patrick's thoughts on this, but let me just add another dimension here, which is what exactly is the question of privacy? I mean, is it your view? Is it either of the three of you's view that these bills are really sort of aiming for something that they're not properly hitting, which would be privacy regulations, right? Or regulations that might give consumers greater knowledge of the way their information was used? Patrick or Arthur or Prince, what are your thoughts on that point?
Yeah, I think the privacy point is well taken, and I think that's somewhere where Congress, there's like, I think everybody agrees there's sort of this kind of gaping hole in the regulatory space that needs to be addressed in one way or another, because you've also got states now passing privacy bills, and you're creating a patchwork of privacy regulation that's going to harm innovation a lot, and so if you really want to talk about leveling the playing field, making everybody kind of play on the same playing field as a federal privacy standard is a great place to start. And then maybe we can start talking about some of these other issues. In terms of just some of the broader point about tying in lines of business restrictions, again, I just want to take it out of the cyberspace realm and bring it into the physical space realm and look at, are these things, did we consider them a problem when Walmart, CVS, Target, and all that offered their generic brands using consumer data? Most people like those things. Most people like having a lower cost good and service. And in terms of bringing it back to cyberspace, I think that the friction between consumers choosing between, say, like a Google map and a Yelp review or whatever, we're talking about people scrolling a little bit down a page to get from the Amazon Basics product to the name brand product, or scrolling a bit down from the Google review to the Yelp review. And so the friction here for consumers to choose is already really, really low. And this just seems like a really heavy-handed approach for an area where the consumer is, pretty empowered.
Prince, what is your view about the point Arthur raised about consumers really do like a lot of these things that these bills seem to be targeting? How do you respond to that?
Sure. I also use the goods and services that we're talking about, but we're in a situation where innovation, we don't know what we haven't seen yet, right? The innovation that could be, but because there are, gatekeeping platforms that are limiting to what we know, these are the things that we can argue. And I do want to talk about the consumer friction point. In particular, it's not as simple as scrolling down, just to respectfully disagree with Patrick. It's not as simple as scrolling down. Google sometimes puts things on second and third pages or completely deletes them from view. We know that over 90-something% of users go to the first page of Google and that's it, right? Because they're trusting that a platform is through non-discriminatedly posting what is best and most accurate to my search query, not what's best for their bottom line. Right. And because the rules are fuzzy and we've seen reports and, cases, we know that that's not the case, that the best results aren't necessarily appearing at the top. And the tying and bundling point, oftentimes what these companies are doing is they will, observe, a sub-market or a product line. They will acquire the IP for it. They'll build a makeshift model that's just good enough, a beta version, just to stick it out there. And then they will really rely on their platform dominance to drive people to that, line of business. I'm thinking in particular, Google and Google Flights, let's say, right? Like, Google builds the bare bones of a Google Flights, right, thing that does what other services have been doing for over 20 years. And then through driving people to that platform, they improve the service, right, with their, machine learning technologies and other things without actually competing for it. They put something in the market that isn't the top product, but they put it at the top of the page like it is because they're self-preferencing.
Right.
And they're relying on people to just improve their product through time and not adequately competing for people's loyalty.
So again, if you want to jump in, this is good. We're getting a good back and forth. I do want to raise this issue, and I cannot recall on which of the documents that each of the three of you sent. And thank you for sending those. We've got a lot of documents on the page for this event. I'll share it in the chat screen. On one of them, I saw a really interesting diagram that showed, American tech companies, European tech companies, and Asian or Chinese tech companies. And there were a lot of big ones on America and China, but not on Europe, which kind of like leads to this notion that Europe has been driving the antitrust train against these big tech companies from a kind of a competitive standpoint. But I want to just come back to the Asia and the Chinese competition argument. And I must confess my bias here is that whenever someone pulls out the national security card, they're hiding some bad argument, like AT&T when the antitrust case was coming against them. Oh, there's going to be national security problems if we break up AT&T, and of course there were not. It was done, and a good thing too. So I do want to kind of just engage on this China question, right? And each of you, your perspective on it. Like, I mean, from one perspective, is there really a threat of TikTok or other companies making use of data that others can't? Is that really a problem? Or is, by contrast, you know, one of you again mentioned the legislation that is going, the U.S. Innovation Competition Act. Please make the case that you know, this law this bill we're talking about here, you know, is kind of tackling the problem the wrong way, and we should be, if anything, preferencing these big tech companies in order to compete with Chinese companies. So I'd love each of your thoughts on this question of the China-America competition.
I'll jump in real quick because my group's kind of making that argument significantly here. You know, I think at a different level of the stack, you know, you've got the FCC kind of making that argument for us because they are ripping and replacing Chinese gear out of the wireless networks and out of our telecommunications networks for fear of what's being done with the data and the potential harms that are there. So at another level of the stack, I don't know why we would build in a door for Chinese companies to be able to harvest data from the Metas and the Googles of the world in order to build their own platforms or do whatever happens with that data if it goes into a black hole in China. But there's also just sort of the overall national competitiveness angle, which is not necessarily the direct risk to the app itself, or the software ecosystem itself, which I do think is present. You know, and it's everywhere from state actors all the way down to just making it easier for the hacker in his basement to get access to Americans' personal devices. But the national competitiveness angle is you're looking at who are the major companies in the United States that are making investments in AI, making investments in quantum computing, and they're the companies that are targeted by this legislation, trying to cut them down to size. And you have to wonder if the line of business restrictions and other restrictions on new investments and mergers and acquisitions harms their ability to invest in AI and quantum computing, which has national security implications down the road. So there's a couple of different angles there.
Yeah,
Arthur,
I'll just piggyback and say quickly that and I stated it before, I'm almost on repeat, that kneecapping U.S. companies without any corollary regulation on foreign companies is extremely bad, particularly when we have foreign rivals in Russia, China, and other places. And so the Ending Platform Monopolies Act, which has structural separation, breaking our U.S. companies up into little companies isn't going to make them more competitive. In fact, it could harm labor markets, and would not allow smaller companies to counter these threats. It is not. I'm not crying about a boogeyman. Repeatedly, daily, monthly, we are hearing about malicious malware attacks from China and other places. And so we really do have tech rivals that are seeking information from U.S. companies and U.S. users. And so the threat is very, very real.
Prince, your response.
Sure. I do want to say in particular, right, I'll talk about the Senate legislation, the AICO, which is an acronym, it's still growing on me. But the AICO, it empowers companies to make affirmative decisions to protect consumer data and business data from being harvested by China or other adversaries. So, in a list of, anti-competitive conduct that it, says is prohibited, right? They make a carve out in particular for in 3A8, where covered platforms prevent users from uninstalling pre-installed software or configure default settings to steer users towards covered platform products. They prohibit them from doing that unless, right, that doing that would, unless, doing those things, allowing, not allowing consumers to change default settings or not allowing consumers to default to delete pre-installed software would, help hurt consumers in terms of their security or prevent that data from going to China or other foreign adversaries. And that's mobile. And, the idea that, hurting these are hurting U.S. companies to the point that they can't compete is simply not true, right? Their valuations are so large, their R&Ds are so large, they will adapt and overcome to these, prohibitions on certain behaviors that have given them an unfair advantage. But the idea that they will continue to fight and continue to produce great products for us, I don't doubt. But let's make room for other great products as well. And that's really all that we're arguing here.
Okay, I'm going to ask a tough question of each of our panelists, and then you can also answer your final thoughts. Okay, so Arthur, the question is, I asked it before, but let me ask it again. What is different between the behavior of these companies and Microsoft, which again, CCIA was aggressively against? And Prince, a question from one of our panelists here is, a quadriplegic uses voice commands and a smart speaker to control devices. And this person has a worry that this bill may make it harder to take advantage of those sorts of tools. And then for Patrick, is there any risk that your promotion of this bill and the kind of the closed ecosystem? In some ways, are you putting your fist on the scale in favor of an iPhone platform instead of a more open platform like Android, et cetera? So let's do it in that order. Arthur, Prince, and Patrick.
Okay, I'll just say quickly that generally CCA is of the mindset, and we support that regulation should apply across the board, not to specific companies, and regulation should name bad behavior, not companies, as is the case here. And quickly, if I could just respond to Prince's point about the exceptions for not allowing information to be passed to government-controlled entities controlled by the government of PRC or government of another foreign adversary. That the limitation applies to information that is given to companies that are controlled, actually business users that are controlled by the government of the PRC. And so many of the other individuals, such as Baidu, Yandex, and others, there's no evidence that they're controlled by the PRC or any other company. And then moreover, it is nowhere defined who a foreign adversary is. If you look it up under case law or statute, it's not stated who a foreign adversary is. And so therefore, it leaves open the problem and the defenses with respect to security for them to apply. They've got to be narrowly tailored, non-discriminatory, and they cannot have a material harm to competition. And so they're so circumscribed that they're unavailing and really are not even helpful.
Well, thank you for joining us and for those comments, Arthur. Prince, your response to his and other questions made here.
Yeah, I'll respond quickly to Arthur, of course, in intellectual and legal fun. So the bill actually, it doesn't explicitly define, the non-discrimination bill doesn't explicitly define what a foreign adversary is, but it refers out to another provision, right? That a foreign adversary, as mentioned in 8C, is what it would be in the Secure and Trusted Communications Network Act of 2019. That's an NTIA, right, law that empowers NTIA, an agency already making decisions and already, deciding who foreign actors are, and particularly in the telecommunications markets, to also designate who those actors might be acting in concert and designate them. So no, they are defined and they are modal and, moving on purpose, right, to empower the proper agency to make that call. And that is there. But also answering the prompt that you had given me, Drew, about whether any of the bills restrict a quadriplegic user's ability to use voice commands, for example, or will these services get peeled off and hurt? No. And in particular, I want to use this moment to flag something that public knowledge has thought a lot about, which is the interoperability, this idea that multiple platforms and services should should work together, right, with and integrated with smaller companies, and smaller companies should have access to the large, networks of larger platforms in order to level set those network effects, right? One of the market problems. In particular, the Augmenting Compatibility and Competition by Enabling Service Switching Act, or the Access Act, sponsored by Rep. Scanlon of the 5th District of Pennsylvania, would require that large platforms make their user data portable to other services, right, within reason, as well as, make their service interoperable, so that a quadriplegic could use any speaker that he, she, or they would want to with any platform or any service, right? And instead of relying on, individual platforms to eventually see, and maybe like a disability organization, fighting every single platform for visibility, it might be possible that they do either, create some headway with one company or a few, and through interoperability, the effects of that technology and that integration mandated by law could actually be spread to the entire network and infrastructure of social media and platforms.
Well, thank you for those comments, Prince Albert, and for being with us. And let's give quick final thoughts to Patrick on my question about ecosystems.
Yeah, sure thing. I'm happy to answer that question. And thank you again to Broadband Breakfast for this, and to my fellow panelists. I really appreciate it. This was fun. So to answer that question, whether or not, we're just trying to favor an iOS ecosystem versus another, I'm trying to favor what I see as the revealed preference of the market. You've got Android and iOS that came into the market, that the smartphone market, admittedly a smaller market, that was at that point dominated by BlackBerry and Microsoft operating systems. And consumers chose, internationally, they tend to choose Android, but in the US, you've got close to 50-50, I believe, iOS, Android. And I just want to leave that choice up to consumers, because for the real tech savvy folks that are out there, a more open ecosystem is great. And these are the folks that can better defend themselves against malware and other intrusions and things like that. They're more tech savvy. That's great. If you can make an Android work better for you, have at it. I know a lot of tech savvy folks in the space that do prefer Androids, but people should still have the choice of a foolproof system like iOS. I'm not the most tech savvy person. I don't want to accidentally download malware. I don't want to have to think about who I'm buying an app from. As long as it's been vetted in the App Store, I can therefore trust it. And I think that actually behooves competition, that people can compete on how their apps work versus building public trust in them. You can borrow some trust from Apple or borrow some trust from Google Play in order to enter the app market. So I think there's actually a pro-competition angle here that is being ignored. So that'll be my final thought.
Okay. Well, thank you to our panelists who stuck around, and for our audience as well for a few more minutes. Very vigorous discussion. On behalf of Arthur Sidney, Prince Albert, and Patrick Hedger, I'm Drew Clark of Broadband Breakfast. We'll see you next Wednesday at 12 noon Eastern Time. Take care. Bye-bye.